Everyone's welcome to today's meeting of the Public Accounts Committee. Can I ask you to ensure that you turn off your mobile phones and electronic devices, with the exception, of course, of your tablets, which contain your electronic committee meeting packs. I have to point out it's not sufficient to put mobiles on silent mode, as they continue to interfere with Assembly recordings. The session is being recorded in video and audio and can be accessed live by way of online streaming, either on the Assembly website or on Democracy Live. Members, I have received apologies from the Chairperson, Mr Clark and Mr Flanagan. Are members aware of any other apologies? Agenda item 3, minutes of the meeting of the 24th of February 2015. Members, the minutes of the last meeting are now being tabled. Members, are you content for these to be signed into the record? They have now been signed. Item 4, correspondence. There are no new items of correspondence. Item 5 on the agenda, matters arising. There are no new matters arising. Agenda 6 is the inquiry into managing and protecting funds held in court, the evidence session. Members, you have a list of people in the sequence in which I will call you. Members, we will now turn our attention to the evidence session for the inquiry into Department of Justice managing and protecting funds held in court. Do any members wish to declare an interest in this matter? We have today with us Mr Nick Perry, Accounting Officer, Department of Justice, Mr Ronnie Armour, Chief Executive, Northern Ireland Courts and Tribunal Service, Mr Richard Ronson, Deputy Accountant General, Courts Funds Office, Northern Ireland Courts and Tribunal Service, Mr Kieran Donnelly, Controller and Auditor General, Northern Ireland Audit Office, Mr Jack Leabery, Treasury Officer of Accounts, Department of Finance and Personnel. Members, you will find biographies of all our witnesses here today at pages 9 to 12 of your electronic packs. That's the blue packs for those not using the electronic system. Thank you for joining us today. You are very welcome to the committee. We will begin with a few questions from the Chairperson or Acting Chairperson, and I wish to direct the first question to Mr Nick Perry. The Court Funds Office provides a service to some of the most vulnerable members of society. What steps are you taking to address the governance, performance, management and quality of service issues raised in this Audit Office report? Mr Perry.
Chair, thank you very much. In answering that, perhaps I could just say at the outset that the Department welcomes this report and make 3 quick points which go to the question you've just asked about the work of the Court Funds Office. The first is that the core purpose of the CFO is to protect the investments of vulnerable clients on behalf of the Court. The CFO is neither a commercial investment operation nor a normal civil service business department. It is a department of the Court operating under judicial direction. The second is that this aim of protecting client assets fundamentally determines the way the CFO approaches its task. It deliberately manages funds in a careful and cautious manner and works hard to ensure that its 14,000 clients receive a tailored, reliable and, where possible, personal service which meets their needs. And the third point is that I accept that there is more we can do and that aspects of modernisation have been too long delayed. To that end, I've asked the Chief Executive to put in place a programme of work to implement the audit report's recommendations. That work is already underway, and Mr Armour will update the committee on progress and outline his action plan moving forward. But in terms of the general approach to responding to the report, Chair, we accept that there is more we can do to strengthen governance arrangements in relation to the CFO, and we are taking steps in appointing an additional financial member to the Judicial Liaison Group, which oversees the operations of the office at a strategic level. We're looking at putting a representative there to represent customer client interests. We are taking steps to improve transparency and to improve the IT system. But it's perhaps worth just saying at the outset that the CFO is already subject to very considerable oversight. It is unique, I think, in the DOJ's bodies in that it is subject to oversight by both the judiciary and by the civil service, in that the court oversees its work, the chief executive oversees its work, the JLG, the Judicial Liaison Group, monitors it at a strategic level. The Court Service Management Board monitors progress, and the chief executive will be reporting to me and to the departmental board quarterly on progress in implementing these recommendations. So there is a great deal of oversight and accountability already built in. A lot more is happening, building on the recommendations in this report. It's a report we take very seriously, and the CFO's duty to its client and the court is something we take very seriously.
Well, I'm sure the members will be consoled that you're taking the report very seriously. Certainly, I can assure you my colleagues took the report very seriously. I will have some very searching questions to ask your team today, and not least the fact that you had the same stockbrokers from 1930. That's an astonishing fact. The Audit Office report indicates that there is little information available with regard to the performance of the Court's funds account. Can you provide the committee with an oversight of how well has the CFO performed against its 2013-14 targets? And remember, you've already just told me in your opening remarks that you can do more, that there's considerable oversight. Indeed, you went on to say there's a great deal of oversight. The members will be most interested to hear about this.
Right. Well, perhaps on the detail of the performance against targets, I could ask the Chief Executive to reply on that. But in terms of transparency generally, the Office has been doing a lot to try and make more information available in its annual report on the website. In terms of performance of investments, I think the investments are outperforming the market and have been doing so since 2011. A great deal of work goes into dealing face-to-face with clients and making sure that they have the information they need. But on the specific point about targets, perhaps I could ask the Chief Executive to reply.
Thank you, Chair. We do have performance standards which we publish in our annual report and accounts, and also available obviously on the Court Service website. We are achieving all of those standards in terms of the service that we're providing, looking specifically at the administrative service. In terms of our stockbroker, we don't have specific targets in terms of the performance of our funds, but we do benchmark the performance of our funds against the FTSE All-Share Index and indeed against other neighbouring jurisdictions. And in each of those benchmarking exercises, we're currently performing higher and have been consistently performing higher since 2011. I mean, the committee may wonder why we don't have specific targets in terms of the stockbroker, and I suppose that goes to the nature of the Court Funds Office. We're not a commercial organisation in the sense that you would normally expect in dealing with investments and the like. The business of the Court Funds Office is centred in protecting court funds, and as Accountant General, that's my statutory obligation to protect the funds which are held in my name and for which I'm accountable to the court. So in a sense, we don't have the targets for stockbrokers, because it's not about them going out there and taking risks to increase the value of funds. It's about protecting those funds. But I think it is encouraging to be able to report to the committee that the values of those funds are rising, and we are outperforming in terms of neighbouring jurisdictions in the FTSE All-Share Index.
Now, I can understand, Mr Armour, that you're not going to invest your funds in oil wells that may not exist in Australia or gold mines in Africa or whatever. But surely you do have a responsibility to ensure that the most vulnerable people whose money you have is actually benchmarked and invested in the best possible way.
We absolutely do. Both I and my colleagues in the Court Funds Office take that obligation extremely seriously, and as does the Court. And the Court will pay very particular and careful attention to the work we do and to the investments we're making. We have a stockbroker. That stockbroker advises us in terms of the investments we should make. The investments are divided into three portfolio types. And I can, if the committee wish, sort of talk you through each of those. The three portfolio types are invested depending upon the client needs and are invested with consultation with the client and with the Court. And it's through those funds that we balance our performance, looking at the funds, how they're doing, and benchmarking them against others.
Okay. Well, obviously, my colleagues will want to ask you some pertinent questions about that, and I'll leave it to them to do that. Clearly, we're interested in the reasons why, in the past, this fund was not managed in the way it should have been. And we certainly will want to know why people were either sitting on their hands or just were not interested in what was happening. Could, in the interest of accountability, you would agree it's vital that public sector bodies manage their performance, and you have outlined how it probably is happening now, and I suspect since this report was published, perhaps not. However, in this case, the Court Service Management Board did not discuss the Court Funds Office's performance at any meeting between February 2006 and June 2012. I would refer members to paragraph 2.3 on page 10 of the Audit Office report. Can you explain, Mr. Lafferty, I think?
Yes, I was the Chief
What
Executive.
on earth was happening for 6 years when there wasn't even a discussion taking place?
That's because I had established a Court Funds Judicial Liaison Group with the explicit responsibility of overseeing the work of the Court Funds Office. I thought it was much more appropriate that we would have an oversight body designed specifically to look at court funds and representative people who would have had an understanding of the nature of the work of the Court Funds Office. That was one of the recommendations of a consultancy report that I commissioned in 2003. And as I say, I established a judicial liaison group, which at the time I co-chaired with one of the senior High Court judges. And I think that was a much more appropriate oversight mechanism than the management board of the court service.
But Mr. Lafferty, a liaison board, I can understand that's very important in bringing people together, but surely it falls far short of a body that would be responsible for monitoring the performance of the CFO.
No, with respect, Chair, that was explicitly the role of the liaison group. It received reports on the performance of the Court Funds Office, and that was the purpose for which it was established. It was also there to reflect the views of clients of the Court Funds Office. So we had, for example, the Master of Care and Protection, many of whose clients were also clients of the Court Funds Office. We also had the official solicitor to the Court of Judicature, many of whose clients were clients of the Court Funds Office. We also had senior judicial representatives from the County Court. So I would argue that we had a bespoke oversight arrangement that was much more tailored to the business of the Court Funds Office than a general management board for the court service.
Okay, we'll just park that for a moment, and I'm sure some of my colleagues will want to pick you up on that because it seems rather strange. At paragraph 2.7 on page 11 of the Audit Office report, we are told the Court Service has been considering establishing a statutory investment advisory committee since 2007. Would you tell the Public Accounts Committee how well that has progressed?
Well, we certainly intend to establish a statutory committee, but putting a committee on a statutory basis doesn't change in any sense the function it discharges. When we enact new legislation, which we're committed to doing, we will almost certainly replace the liaison group with a statutory version of the same thing. But putting it on a statutory basis is to my mind, a secondary issue. The main thing is to have an oversight mechanism for the Court Funds Office. Whether it's statutory or extra statutory doesn't seem to be materially significant.
Sorry, you're confusing me, Mr. Lafferty.
I beg your pardon.
You're confusing me. Perhaps you can clarify it. Why then are you considering establishing a statutory investment advisory committee since 2007 when you just told us, well, it's not really important anyway?
No, that's not what I said. I said that we had already put in an extra statutory committee, in other words, a non-statutory committee, which is the Court Funds Judicial Liaison Group, which I established in 2005. When the opportunity arises to change the legislation, we will almost certainly bring that on to a statutory footing. But I'm saying to the committee that I don't think its statutory status would materially alter the function it discharges.
I think, if I could comment, Chair, the important thing for me, I think, is to ensure that the Judicial Liaison Group is as strong as it possibly can be. I think, as Mr. Lavery has indicated, we would want, when the opportunity is there, to take legislation to put the committee on a statutory footing. But in the interim, I think the important thing is that we make sure that committee is as strong as it can be. And I'm currently looking at how we might do that. I think the report that we have in front of us helpfully suggests that we should strengthen our independent financial advice, our expert on the committee. And we will, in April of this year, be appointing a second independent member to the committee who will bring with him very significant financial expertise. So I think that's a positive development. The report also recommends that we need some consumer representation on it. Now, I currently have the official solicitor sitting on that group, and I've been working very closely over the past number of months with the official solicitor. I mean, she is in almost daily contact with clients, and I think is very well placed, perhaps uniquely placed, to represent their views. Nonetheless, having said that, one of the things that I do want to do is to take the recommendation in the report and to appoint an independent consumer representative. And we are putting steps in place to work towards doing that as quickly as we possibly can.
Well, when you say quickly, can I ask, why has it not been implemented sooner, and when will it be implemented?
Well, I received this report when I took up post in September of last year. I have already discussed with the Judiciary and with the Judicial Liaison Committee the need to implement the recommendation in this report. Court funds, is a complex area, and we are dealing with some very sensitive, very significant issues. For me, it's about getting the right person. We could go out and we could make an appointment of an independent person to come and sit in the committee, but it's about getting the right person that is best placed to cover the wide range of individuals that we're currently caring for their funds.
Mr. Armour, you say you took over responsibility in September.
Yes.
A couple of short questions before I move to the members. Were you shocked with what you found in September?
No, I would have to say that I wasn't shocked with what I found, Chair. I mean, I've had an opportunity, I suppose, to look at the Court Funds Office
you suppose. I would rather you would be definite.
Well, I'll be definite. No, I wasn't shocked with what I found. I mean, I've been, in all honesty, very impressed with the staff in the Court Funds Office, with the job that they do. I've been impressed with the relationship that we have developed with the stockbroker and the way the stockbroker is overseen both by the staff in the Court Funds Office.
This question may come up later. Who is the stockbroker responsible to?
Well, the stockbroker is appointed by the court services. Ultimately, I suppose responsible to me is would be responsible to me as the Chief Executive and Accountant General.
Adrian, I'll move over to you.
Thanks, Chair. Just a couple of wee questions on the back of what you've been saying there. You know, you talked about, Mr. Lambert, you talked about referring the views of the clients to the Oversight Committee. Just explain to me how that happened, you know, how that worked in reality.
The views of the clients? Well,
yes.
The views of the clients are central to the work of the Court Funds Office. There is contact right at the beginning when funds are brought into court to ascertain the needs of the client. Those can vary, of course. You might have an elderly person who requires a regular income. You might have a young person whose money will be held until they're 18, so that the money really is to be preserved for them. So we discuss with the client or their representatives on an individual basis what their requirements are. Then we refer the matter to the stockbrokers to advise on the appropriate way of achieving those interests. The stockbrokers have essentially three, in broad terms, three portfolio strategies which are designed to meet particular needs such as income generation, capital preservation and so forth. And then we put the stockbrokers' recommendation before the judge of the relevant court for approval. So on a case-specific basis, the needs of the client are taken into consideration at the point when the investment is being made. The point I was making to the Chairman was that in addition to that, the Oversight Committee, called the Liaison Group, also has members on it who deal with a large number of clients of the Court Funds Office. The official solicitor to the Supreme Court represents, as the solicitor, quite a large number of the clients and is on the Liaison Group. And the other figure who would represent a lot of clients is called the Master of Care and Protection. The Office of Care and Protection is part of the Court of Judicature that deals with patients. That's essentially people who cannot manage their own affairs. The Master of the Office of Care and Protection is also a member of the Oversight Committee. So both of those people can speak on behalf of the service being provided to client groups that are very much making up the majority of the clients of the Court Funds Office business.
Yeah, thanks for that. Just a wee bit clear in my own head if
yes.
I couldn't get it in
sure.
what we were thinking. It seems to me with what you're saying there is that there is a lot of trust based on the stockbroker and his advice, you know what I mean, and that.
Yeah.
Is that always taken, his advice always taken or chatted about through the Oversight Committee?
Well, the Oversight Committee doesn't look at individual investment recommendations. That's the job of the judge who's dealing with the case. The first port of call, though, would be Mr. Ronaldson and the staff of the Court Funds Office. They would look at what the client has told them about their requirements, and would also look at what the stockbroker is recommending. And if there's any challenge to be done, it would be done at that stage. But the final decision as to endorsing the stockbroker's recommendation lies with a judge or a High Court Master. So there's as Mr. Perry was explaining, there's really two measures of scrutiny. There's the work that the court service does through the Court Funds Office, and then ultimately the decision of the judge whether or not to approve the stockbroker's recommendation.
Thank you. Now, Mr. Perry, the fund holds around 280 million on behalf of 14,000 clients. That's a lot of money, yet we were told in paragraph 2.8 on page 11 that none of the groups overseeing the work the CFO has the necessary independent financial expertise to challenge investment policies and strategies or assess the quality and the advice provided by the stockbroker. It's very concerning that the CFO manages £280 million but doesn't possess any independent financial expertise.
Well, I think the JLG since 2011 has had an independent board member on it who has a financial background, and as Mr. Armour has just been explaining, we've now reinforced that with the second independent financial member with particular expertise.
But that has been reinforced on the back of this report.
That is true.
You know, I mean, if it hadn't been for this report, it might never been reinforced.
Well, that is true, but in terms Parrot 2.11 refers specifically to financial expertise, and that's correct. But in terms of independent scrutiny of investment decisions, as Mr. Lowry's just been explaining, of course, there isn't intense scrutiny of and has been for many years of individual decisions by the court, by court service management. Intelligent, experienced people with a great concern for the clients and for doing their best for them. So we've certainly recognised the need to reinforce the financial expertise in that area, but there has been a great deal of independent scrutiny for a prolonged period.
Yeah. Well, I'll move on then to Mr. Ronaldson. Paragraph 2.11 on page 12 indicates that you haven't enough staff appropriately qualified to review the challenge investment recommendations. Why has the skills gap not been addressed before now? And has it been taken addressed now as a matter of urgency?
Where it says the recommendation is to identify any skills gap if it is there.
This report says it's there.
I think in fairness, Chair, that might be a question for me rather than for Mr. Ronaldson, who is a member of staff in the office. If I could maybe help you with that one.
Mr. Armour, sorry, no due respect or disrespect. I would prefer the members choose the person they ask the question.
Well, let Mr. Ronaldson answer it, and then you can back it up after.
I mean, since just before 2000, there has been a qualified accountant in the office. We currently have 3 qualified accountants within the office, and there is oversight by another qualified accountant. And obviously, then with the JLG, there is the independent member. The scheme of qualifications that were introduced back in 2010 were really to help us become an intelligent customer, to give us a bit of experience, a bit more knowledge, and enhance the knowledge of the accountants already in post. The actual investment recommendations come in, and they are dealt with by the investments team, which is a small team within the office. So where we have 3 members of staff qualified by the Securities Investment Institute, I believe that is sufficient. Now, what we are planning and doing is to run in-house training to the office.
So it's not really sufficient if you're going to run in-house training, or it's not sufficient what's there now at the minute. Is that what you're actually saying?
I believe it is sufficient, but to I suppose enhance the knowledge within the office, we're just going to run in-house training to try and provide or feed down some of that expertise to the other members. It helps with for example, cover during leave periods and things like that.
Fair enough. Mr. Armour, do you want me to add?
Mr. Ronaldson has answered the question very fully. I would just make the point. I think when the report was written, Court Funds Office were dealing with an issue called flexi orders, and I think that is probably the issue that the Audit Office had in mind when they made this when they made the comment and the recommendation. Court Funds Office is no longer dealing with flexi orders. We now have a very experienced stockbroker who is there. The role of the Court Funds Office is about overseeing the work of the stockbroker. As Mr. Ronaldson has explained, the qualifications that a number of senior members of staff within that office currently have, and I'm currently satisfied that we do have the skills that we need to do the job that's required of us at this point in time. Having said that, as I indicated earlier, we're bringing a second financial expert in to work alongside us, and I would certainly be willing to take his mind on that issue as well as a point of reassurance.
Paragraph 2.17, we're told that, sorry, 2.11, we're told that the CFO is awaiting the outcome of a court case before reviewing the need for further staff training. And then we're told that although work has commenced on drafting a programme of legislative reform, it will take at least 3 years to introduce. Could you reconcile that with the evidence that both you and Mr. Olson have just given this committee?
Well, we have received the outcome of that court case, and on the back of that, I am content that the staff are suitably qualified for the job that they are currently doing. But staff training is an issue, I think, that is rightly kept under consideration, and that's why I'm saying to the committee I would want to take the mind of the financial expert that we're bringing in, just to reassure myself that that I am right in my assessment.
Mr. Lafferty earlier just told us that the stockbroker is responsible to a judge. Now, far from me to offer an opinion on any judge, I assume he has no particular expertise in investment and finance. And then we have...
Well, he would certainly have considerable experience of approving investments.
Don't question that, but I'm talking specifically about the ability of a stockbroker to be doing the right thing.
I think the stockbroker does his job and the judge does his or her job in the sense of challenging and testing the match between what the stockbroker is proposing and what the client requires. But certainly the judges aren't second-guessing the stockbroker's advice. The stockbrokers were procured competitively and they're one of the top 20 firms in the United Kingdom. So we're satisfied with the expertise we have there. I don't think it's really appropriate to try and sort of duplicate the expertise somewhere else in the system. We pay the stockbrokers to provide expert advice. It's scrutinised by the Court Funds Office and ultimately
indeed,
by the judge.
You paid the stockbrokers a great deal of money, and I'm sure my colleagues will remind you of that later on. Adrian, are you?
I have just one more question, Chairman, and that's me finished. Just Mr. Armour, it seems to me where I'm sitting here that if this report hadn't been produced, there'd been no changes in the CFO's office at all. You just carried on the same old.
Well, I wouldn't accept. I wouldn't accept that. As I was saying earlier in response to a question from the chair, having looked at the work of the Court Funds Office with fresh eyes, being recently appointed, it is clear to me that there has been consistently over the past number of years a desire and a willingness to continuously improve the work of this office. And I think when you look, the chair referred to the past 10 years. When you look over the past 10 years,
between a desire and willingness and actually doing something.
Well, I think the
desire and willingness to be the First Minister, I doubt I'll ever make it.
When you look over the past 10 years, I think you can see at key junctures progress that has been made. Now, I would accept, has progress been as quickly as colleagues would have liked it to have been? No, it hasn't, but there have been a number of reasons for that in terms of legal challenges that we had to wait the outcome of. But there's certainly been a lot of developments. I mean, Mr. Lavery mentioned the establishment of the Judicial Liaison Committee. There has been a modernisation programme that has taken a number, I think, of positive steps. We've introduced investment strategy guidelines. We've closed a number of sub-accounts in terms of rationalising. We've taken legislation in terms of a number of small clauses in legislation over the past number of years that have assisted. Is there still a long way to go? Absolutely, there's a long way to go. And that's why we put the modernisation programme in place. And as Mr. Perry indicated, I'm accountable to him and to Mr. Lavery, both in terms of performance management and wider accountability for the delivery of that programme.
Before calling, I think Mr. Beggs wants to interject. Just to make sure we understand each other, Mr. Lafferty, I'm getting the impression, chairing this meeting, that the message you're giving us that everything is absolutely rosy in the garden, there's no need for change. Hopefully I'm picking up from Mr. Armour that actually there's a great deal of need for change. Which is it?
Well, I have, of the people at the table, I have the most experience of this. I was Accountant General from 2001 until 2012.
Not the best period, I would have thought.
No, I dispute what you're saying, Chair, and indeed you said in your opening remarks that this organisation had not been managed properly, and I dispute that entirely. There's no basis in the...
Well, Mr. Lafferty, is there any point really in discussing this report? The department's already accepted it.
We accepted the recommendations in the report. That's correct.
It is damning.
No, it's not
in the
damning.
past.
It doesn't sustain the remark you made in your introductory observations. I commissioned a major review of the Court Funds Office by Amtech, the consultancy who also advise the Court Funds Office in England and Wales. It reported in 2003. It made a wide-ranging number of recommendations, and we have implemented, in whole or in part, the recommendations in that consultancy. So, for example, it recommended the competitive procurement of a stockbroker service.
Can you tell me when that started,
we did that.
Mr. Lafferty?
The report was in 2003, and we began a procurement exercise in 2005. The actual procurement was interrupted for legal reasons, but it was completed in 2008. And then we had a further procurement in 2013. But the point I'm trying to get across is Mr. McQuillan's point that if we hadn't had the Audit Office report, nothing would have been done. I think that would be an unfair reflection on what the Court Service did. We commissioned a major review in 2003, and we've implemented the greater part of those recommendations. We welcome the Audit Office's further consideration and Mr. Armour's taking forward those further recommendations, but I think it would be wrong for the committee to form the impression that nothing was done to improve the Court Funds Office. And some of the things we've already discussed are specific examples of that. When I was appointed, there was no oversight body for the Court Funds Office. Amtech recommended one, and I appointed one. And I think that is an improvement. I didn't have the Audit Office to tell me that. That was put in place as a very early improvement. So I think it would just be misleading for the committee to form the impression that nothing happened or would have happened until this report came out.
Well, I would certainly hope that no one accuses this committee of misleading anyone. Our evidence is based on a report which has been agreed
Absolutely.
by the department.
And just, if I may,
Mr. Beggs.
I'm just trying to get a clearer picture of how the whole system works together. One of the comments I picked up there is the investment is determined by the judge in individual cases.
That's correct.
Then there's the 24 administrative staff, and then there's the professional stockbroker who has been brought in to do the investment. What does the judge actually determine?
The judge determines whether the recommendation by the stockbroker is appropriate for the client's needs, and the judge will look to the Court Funds Office to have explored the client's needs with the client or their representatives. So the judge, ultimately, the investment is made on the order of the court, and the judge makes that order.
So we have, I'm told you have something like 14,000 clients.
That's correct.
So there are presumably 14,000 meetings with a judge on a regular basis looking at whether the investment is gone.
No. These, that'd be misleading, Roy. A lot of these clients will have investment packages in place for many years. Okay. The judge would only have to look at the case again if the investment was going to be altered or changed in some way.
What I'm trying to understand is most people, if you want to invest money, you keep some in the bank for quick access.
Yes.
And after that, you then determine the level of risk and reward.
That's right, yeah.
Why does the legislation not allow your system to operate in a similar fashion?
Well, we do.
Without the intervention of the judge, and to minimise a judge's time, because if it's simply down to reasonable reward without undue risk, is that not all that's needed?
It is, and when the money, but this money is being managed on behalf of the client by the court. That's the job of the court. The law requires the court to manage the fund on behalf of the client, and as the committee knows, the clients are either young people under the age of 18 who haven't the legal authority to manage their own affairs, or patients who haven't perhaps the mental capacity to manage their own affairs. So the court is making the investment decisions on their behalf.
Have you even considered, I mean potentially there's 14,000 different investments to be tracked?
It's true.
Which must be a nightmare, is it? It must be very bureaucratic. Is it time consuming? Yeah.
I mean, yes, we have 14,000 clients. I think it's fair to say, though, 50% of those individuals would have less than £3,000, for example, with us. So that money is held in deposit accounts. So it's not, we don't have 14,000 people with equities and shares.
That was striking me. Have you considered perhaps changing the legislation so you could perhaps have bands or methods of determining the most appropriate investment for someone because of some sort of criteria and a band. So therefore, you wouldn't then need to track every individual criteria. You just have to determine, is this the right band grouping for this individual, and that would considerably reduce the bureaucracy involved in your organisation. Have you considered that?
Well, that's a reflection of, I mean, I mentioned earlier, and Ronnie will say more about it, that the new stockbrokers, Davies, are much more moving into that standardised approach. And they have, as I said earlier... But
the judges is not. The judge is still down to individual cases.
The final decision in every case has to be made by a judge. But it's not as if you have 14,000 different types of investments. You have now increasing standardisation into 3 portfolio groups. And that has been helpful in reducing...
That's a lot less complicated than what you seemed to be talking about earlier on, Bob.
Depends on the size of the case, though. Some cases might require to be tailored very much to the specific needs of the client. But generally speaking, they would fall into those three groups, and then they'll be adjusted according to the individual's needs.
Okay. Thanks, Mr. Chairman.
Mr. Sean Rogers wants to discuss the modernisation programme, and there certainly will be most interested to hear about that.
Just before we go on to that, Mr. Lamprey, you mentioned there about you accepted the recommendations.
Yes.
And what Adrian has been talking about there is the level of expertise in the CFO in terms of investment and in terms of securities. There were about 4 staff, according to the information we have, about 4 out of the 24 staff had actually got some sort of a qualification. So in terms of that recommendation, the court service should identify and fill the skills gap to ensure there is sufficient number of appropriately qualified staff to review and, where appropriate, challenge investment recommendations on behalf of the clients. Could you tell me what have you done about that?
Well, as you've noted, 3 of the staff of the Court Funds Office are professionally qualified accountants, and as Mr. Armour has said, that other staff have accredited training through an appropriate professional body for investments. But in addition to that, Mr. Armour was saying that we are bringing in an additional independent member to join the liaison group to which I referred, and that person is going to specifically look at what skills gap, if any, exists, and will make recommendations to us. Mr. Armour is asking that person to undertake that role as a priority, and if it reveals a skills gap, then we will address it.
So, you don't believe there really is a skills gap?
Well, Mr. Ronaldson said you can always improve. We certainly are committed to continuing professional development of staff, and refresher training and so forth would be necessary and desirable in any organisation. But what we're not doing is training people to be stockbrokers. We've appointed one of the top 20 firms of stockbrokers in the country to provide that service. We need staff with the appropriate skills to work out whether what the stockbroker recommends matches the needs of the client, in order to put the recommendation then to the judge to approve. So I'm not going to train staff or give the committee any expectation I would train staff to do a stockbroker's job. That would be quite wrong. We've hired one of the best firms in the country to do that job. Our job is to test and validate the recommendation they're making against the requirements of the client in the individual case. But if there is a skills gap, we will address it. But I think it will not be in the area of investment knowledge. It may be.
Just picking up on that, if I may, Mr. Rogers, I mean, we're looking for our staff to provide an intelligent customer role around that, to be able to ask intelligent questions. As Mr. Lamprey says, we don't want them. They're not in a position to second guess investment decisions.
And I think the key issue for me is that the senior staff within the Court Funds Office. I mean, you mentioned, Mr. Rogers, 24 staff. That's now fallen back to just under 21 staff through the efficiency programme. But it's about the key people within that office having the right qualification. A lot of the staff within the Court Funds Office are doing administrative work and processing work. Mr. Ronaldson, who's the Deputy Accountant General, and the people who are working closely with him are the people within that office that are qualified and that I need to be qualified.
Okay, thank you. So can I go on to the modernisation programme that was originally planned in 2004 and wasn't finished, and then in 2010 it was agreed that there's need for some sort of legislative reform. I believe some work has begun on drafting that legislative reform, but it will take at least maybe 3 years to introduce that. And even when you have legislative reform, when you have that in, then in terms of modernising the system could take even longer. Why has progress really been so slow?
So, Mr. Can I jump in on that? I mean, to some extent, I think the 2004 reform programme has been overtaken in that key elements of it, as both Mr. Lavery and Mr. Armour were saying, have been implemented. The recommendation to go to open competition for stockbrokers, internal reorganisation within CFO to create a better customer focus, modernisation of annual accounts, the establishment of the JLG, the creation of what are now investment portfolios. So quite a lot of the recommendations, as Mr. Lavery was describing, have been implemented. In terms of the legislation, the run-up to devolution meant that progress couldn't be made on that. Since devolution, there have been a couple of legislative changes taken through, as Mr. Armour was describing, around management fees and around the mechanism for setting interest rates, the CFA's interest rates. As it happened, one of those legislative changes led to the court case that then that lasted for about 3 years, I think, and has prevented further progress. We are committed to legislating in the next mandate, but the nature of that legislation will now depend on a consultation the Minister is considering about the future role of the CFO. And I might, if I may ask Mr. Lavery to say a word about that, if it will help the committee, because he's leading on the policy on that.
Could I ask you, Mr. Lavery, because your answer to me, Mr. Perry, really is that the lack of progress has been, you've been hiding behind the lack of legislation.
Well, it certainly it wasn't safe to proceed with major legislative change until we had the outcome of the court case, because it was quite a fundamental one. But it hasn't prevented some legislative change happening. For example, the work on specific particular issues around the mechanism for setting interest rates. So it's not that nothing has happened, but the major change that was envisaged perhaps before 2010, it wasn't possible to proceed with that. And now, as I say, there's a broader consultation coming which will affect the nature of any future legislation depending on the outcome.
There's a number of recommendations, paragraph 212, Mr. Lavery, in terms of what progress. Can you tell me what progress has been made?
How far do you want me to go back? Because
no, take for example, it's paragraph 212 on page 13 there.
Yeah.
But particularly, okay, this strategic and legislative modernisation takes some time.
Yeah.
But when you look at some of the other ones, like modernisation of the stock contract, and modernisation of accounts, modernisation of transaction processing, review and update of the systems, what progress has really been made there?
Well, the governance arrangement, the first of the bullet points in paragraph 212, has been put in place, not, as I said earlier, not on a statutory basis, but we created a non-statutory committee to do that job, and that's the one that Mr. Armour is strengthening further by bringing on another independent member. So that's in place. What I said earlier was that when we change the legislation, we'll put that onto a statutory basis. But there is that we did revise the governance arrangements. The second bullet point is the modernisation of the stockbroker contract. We procured for the first time, certainly since the court service was established, a stockbroker in 2008, and took the opportunity to introduce new service standards. And then we ran a further procurement in 2013, which led to the appointment of the current stockbrokers. The accounts were modernised and put onto the appropriate government accounting standard. The third bullet point is modernisation of transaction processing. Perhaps it might be Mr. Ronaldson could address that slightly better than I could. The last bullet point is the one that Mr. Perry is referring to, which is the legislative modernisation. The Minister has agreed that we will initiate a consultation, a pre-legislative consultation, later this year with a view to introducing legislation at the beginning of the next mandate. And the point that Mr. Perry was alluding to, I think, was that in the consultation, I think we should ask the fundamental question, which is whether this particular role undertaken by the Court Funds Office should remain the responsibility of the Courts and Tribunals Service. For example, in England and Wales, the Court Funds Office looks to National Savings and Investments to manage a lot of the investments for them. In Scotland, they have a different approach. A lot of the funds that would be managed by the court in Scotland are actually are out of court and managed by the client's representatives, and they're not under the court's protection. And in the south of Ireland, they modernised their system a few years ago and introduced something closer to what we have had in mind, which would be a modernised court funds administration, but retaining the principle that the court is there to protect the clients and should continue to manage funds on their behalf. But I think it probably is worth going back to that fundamental question. There hasn't been a review of court funds or the role of court funds in Northern Ireland in the sense of the appropriateness of the role since the report of the McDermott Committee in 1970, which said that this was an appropriate responsibility for the court to continue to discharge. But I think it would be useful if we asked that fundamental question in our consultation paper later this year.
Okay. Mr. Robinson, could I go to you, and before we look at the modernisation of the transaction processing of the accounts? We have a computer system there that's nearly 20 years old and hasn't been significantly updated for some time. In terms of what Mr. Lavery has just said, particularly in those two areas of transaction process and management of modernisation of accounts, what progress has been made there?
In 2008, we carried out a review of the roles and responsibilities of the staff within the office, and as a result, we were able to provide sort of greater focus on customer services element of those services, and were able to increase the number of staff within the customer service team. This allowed us to vastly increase the number of face-to-face meetings that we were able to have with clients. In terms of the updated systems, we implemented an interface with the ICOS, which is the court operating system, which meant that data was automatically uploaded onto the current CFO system and removed the need for manual processing. So there were efficiencies generated there. And we also removed the number of sub-accounts that we maintained within our bank accounting operations, which enabled us to make full use of online banking facilities and has enabled us to generate efficiency there as well.
Well, what are the problems with the computer system?
The computer system is currently supported on best endeavours basis. So at the minute, it does its job. It's on a stable platform, but we obviously are looking to implement a new system, and we have recently had a business case approved for the procurement of a new system. Now,
you say it does its job. If my computer was 20 years old, I don't see how it could do its job, and at the same time I'm trying to modernise transaction processing and modern accounting procedures. Accounting and transaction processing has changed a lot in 20 years.
Correct. The system itself is a database system. It records transactions, so that at its very basic level. So as a result, we are able to produce accounts from that system. It just takes us longer to do that. And that's where a new system will obviously generate efficiencies in the role of preparation of accounts. We would then hope that the new system would also be able to perhaps avail of automatic bank reconciliation processing, again generating efficiencies. So that's where we're looking to implement the new system.
And in terms of dealing with, say for example, the system breaks down, is there any way that payments can be carried out manually?
Yes, I mean, that at the minute that is our contingency. Where the system, if the system became irrecoverable, we have the backup data every evening, and we would be able to continue to make payments if necessary through our online banking system.
The system is, has been highlighted as a risk, as Mr. Ronalds has indicated. It is 20-year-old. We do have now business case approval for a new system, and money will be available for that in the incoming financial year, and we would hope to have that system in place by the end of the year. But we do have very careful contingency arrangements in place should there be an issue with the system. As Mr. Ronaldson indicated, it would be a manual system, which I accept would be time-consuming, but there are contingency arrangements there, and it is covered within the Court Services Disaster Recovery Plan.
Mr. Armour, would the Ulster Museum not be the best place for your computer?
It may well be, Chair, but it's the system that we have at the moment, and it's doing, it's doing what we require of it, not as efficiently as it should be.
I haven't cut across, Sean, but I mean, you've said it basically keeps accounts.
Yes.
Might even do reconciliation statement. But is it possible to interrogate it to get information out of it that would tell you if your clients are getting the best return on their money? Or have you been sleeping on the need to get a new computer system?
It's absolutely able to interrogate and provide us with information. It's not able to provide me with as much management information, I think, as I would want, and that's what the new system will do. But in terms of the return for our clients, I mean, we benchmark that in other ways. We don't use the system necessarily to do that.
Mr. Beggs.
Struck with the terminology is maintained on a best endeavours basis. Can you explain what that means?
But because of the age of the system, there is an issue with supporting the system, and therefore, if we were to have a major problem with it, it would be difficult, I think, to get it back operating in the way.
How long has it been on this best endeavours backup system?
I mean, the IT system, I think we would recognise over the past number of years has been in need.
For how long has it been classified in a best endeavours maintenance backup?
I think it's something in the region of 18 months. But at that point in time, we then obviously were working on. We got a feasibility report from Fujitsu in terms of what options we had to replace the system, and we then have been working with the business consultancy service of the FP to generate specifications.
It sounds as if you have a very limited group of engineers that might be able to support this system. Would that be correct?
The support of the system is undoubtedly a concern.
So what's the hourly rate that's charged if there's very few people in the world that can actually provide it, and how does that compare with alternative modern?
The system is supported within the current contract we have with Fujitsu, so there's no additional costs if anything was to go wrong. The issue is...
that's what I'm asking. What is the cost?
I don't know the...
Wouldn't have that figure. I mean, we're happy to write to the committee with that figure, but I wouldn't have it.
Then, is there off-the-shelf products that others are using somewhere else? It's not having to invent something bespoke.
No, absolutely not. The new system is not a bespoke system. It is an off-the-shelf system that we will be putting in. So we're not designing something specifically. No.
Okay. Thank you. Okay.
Could it then just go to paragraph 216 and 217? And it gives the details of the estimate of the fees that have been wrongfully deducted from clients' funds. In August 2012 was estimated at 2.9 million, and then it went with interest of 3.7 million, but was eventually reduced to 320,000. Can you explain why you did not have enough information on each case at the time to know whether or not the necessary court order was in place? And put that to Mr. Rawlinson.
The issue of the potential refund of fees actually depended on the outcome of the court case. It was before the outcome of the court case. It was irrelevant whether the the order was in place or not. That was really one of the cruxes of the court judgment. The suggestion was that even in spite of there being a court order in place, the fees were still deducted unlawfully. As a result of the court judgment, we were able to reduce that liability down to the 320,000. We then got further legal advice on what, on the outworkings of the judgment, to ascertain exactly what order we needed and what the wording of the order must be to determine whether the fees were deducted lawfully or unlawfully. The 320,000, we've now done that work. We've reviewed the court orders, and we estimate the current liability is no more than 55,000.
Sorry?
55,000 is the total liability.
So did it start off at 3.7 million, now it's 55,000?
The 3.7 million was basically every single fee that had been deducted, because that was the potential, the worst case scenario if the court case had gone against us. The 320,000 was on the court case, or as a result of the court case, we were able to discount the orders that we were definitely sure of, and then we got further legal advice which has allowed us to discount further orders which we had questions over. So that's why the liability is now 55,000.
Okay, thank you. In terms of ISIS, ISIS worth 9 million were held on behalf of around 100 clients, despite a lack of legislative authority. That's paragraph 218, Mr Lavery. How did that happen?
Well, the legislation establishing the Court Funds Office is quite prescriptive about the types of investments that can be held. ISAs were a relatively new development and post-dated the legislation. We find that quite a number of clients, particularly elderly people, would have had ISAs, and when their funds came into court, the ISA came into court along with their other holdings. We then had reason to question whether it was permissible to hold the ISAs within the court. We took counsel's opinion and were eventually advised that a particular category of ISA could not be held within court for largely technical reasons. And then we put in place a strategy to allow the clients to decide whether to liquidate the ISA and then have the money invested in by some other means, or alternatively to take the ISA out of court. We did that in order to avoid anybody losing the tax advantage that the ISA represented for them. So a number of clients simply chose to take the ISA out of the court so that they could continue to benefit from the tax advantage.
Would it have been related to the lack of independent financial expertise or the lack of qualified staff in the courts? I
don't think so. In fact, we had to go to senior counsel to advise, and it wasn't a black and white issue. It was a matter of interpretation of the legislation. So I really don't think it would be reasonable to say that it certainly wasn't obvious to anybody that ISAs were not permissible. We eventually took senior counsel's opinion, and it was quite a lengthy 12-page opinion arguing that it was a finely argued point, but the legislation inhibits certain types of investment, and ISAs would be perhaps the most explicit example. But I think the way we managed that situation was sensible. We didn't. We allowed each client to decide what to do with their ISA, and they could take, as I explained, they could take the ISA out of court to keep the benefit of that tax advantage to them. Certainly if we modernise, or when we modernise the legislation, we would want to remove those sorts of issues. And I think it simply reflects the fact that the legislation was rather prescriptive and described types of investments in a very particularised way, and ISIS came along later and didn't quite fit into the legislative environment.
Thank you. Thank you. That's me, Chair.
Mr Lafferty, maybe just for the record, you did say there to Sean that you don't think it was a lack of independent financial expertise or a lack of qualified staff that brought this about. if we had the gift of hindsight, then what would have prevented it?
Prevented the ISA issue arising?
Correct.
Well, if we had, it is such a case-specific instance. I mean, what I'm trying to explain to the committee is we had to go to senior counsel to interpret the legislation establishing the court funds regime to see whether an ISA investment was permissible, and it was not. It wasn't a straightforward issue. So I think it's quite a complex issue of statutory interpretation. I really do, certainly wasn't a lack of knowledge on the part of the staff. I don't feel if we had to go to senior counsel to advise on it, it almost by definition indicates it was a pretty complex issue. But there's no doubt one of our expectations when we modernise the legislation is that we will try to make it less likely that this sort of restriction could arise again, because an ISA would obviously, or its recent equivalent, such as a pensioner bond, would be a very useful investment vehicle for an elderly person whose funds are held in court. The point I wanted to get across this afternoon is that we still allowed the clients to keep their funds in their ISAs if they wanted to, but they had to take them back out of court in order to do so.
Mr. Paul Girvan.
Thank you, Chair. Thank you for your answer so far. But I'm quite interested in relation to the subject of the tender process, which, to all intents and purposes, seems a little bit weird that one firm have been able to deliver this from 1930 until 2008 before it went out for a tender process, which maybe I'll ask questions about whenever I do that. Why was there no competitive tender for stockbroker services until 2008? And I'll ask that, maybe David can answer that.
Well, I honestly have no insight to the history of the appointment of the court stockbrokers. The court service, as colleagues will know, was established in 1979. So this contract was awarded by the Supreme Court, or possibly the Ministry of, well, it wouldn't have been the Ministry of Home Affairs, it might have been the Lord Chancellor's Department. We have no records to indicate what process was used to appoint the stockbrokers at that time. But it wasn't an uncommon feature that a professional entity would be appointed to represent the court almost on a permanent basis. For example, the legislation provided that the bank of the court would be the Bank of Ireland, and we've changed that approach as well. We did a procurement of banking services, and we now our banking services provided by Danske Bank, for example. But the legislation actually said the Bank of the court was the Bank of Ireland, and that seemed to be the way this business was organised back in the 30s.
Would it be right to say that it does leave itself open to seeming like a boys' club?
Yes.
And
yes.
very much
yes.
Nod and a wink, and that's the way it's done, and it's dealt with through it. And it does reek of that whenever you can deal with a company that have been dealing with investments on behalf of courts for nigh on 70 years with no, or 80 years with no query whatsoever about what's going on.
Well, I wouldn't want to, I mean, I just have no basis in which I would question the performance of Cunningham Coates. There's nothing I saw in the time for which I was responsible between my appointment in 2001 and the appointment of Brewin Dolphin in 2008 to suggest that Cunningham Coates did not provide a suitable professional service. But what I did do was commission a consultancy report on the court funds, as I mentioned earlier, by the Amtech consultancy, and they reported in 2003 recommending a competitive tendering process. So we initiated that in 2005. I mentioned earlier that the award of the contract was delayed somewhat by a legal issue that emerged, and eventually the contract was awarded to Brewin Dolphin in 2008, and then it's been tendered in 2013. So we're now on a pattern of competitive tendering of stockbroker services.
I want to go into that point, and it's about the tender process. I appreciate we're fishing from a fairly small pool in relation to that matter, and the audit report indicates that the tendering process in 2008 was not robust. That's what is in the report, and there was no business case completed for a contract estimated to be worth somewhere in the region of £430 or £430,000 per year, which maybe I'll ask questions on later on. And despite the fact that the cost of the investment service is borne by the client's fund, and only a small percentage weight was given to that fact, I think it was about 20% weighting given towards that, would you acknowledge that the competitive process was flawed on such basis? Well,
it adhered to the procurement rules that were applicable at the time. We were advised by the procurement office of our service of the then Northern Ireland office, because this was pre-devolution, and the process we used was compliant with the then requirements. So a business case wasn't required, but there was an analysis of the services required. A process that we were advised to implement was followed. There were, I think, 3 companies who made it through to the final selection process, so there was a competitive element to it, undoubtedly. The decision to weight costs slightly lower than quality of service was quite a deliberate one. We chose to give a higher weighting to quality and standard of service than cost. That changed in the subsequent procurement exercises as we gained more confidence of that process. But I think the process was satisfactory and achieved a good outcome. But certainly the one run in 2013 that was under the Central Procurement Directorate rules, and was subject to a full business case process, and the cost element was weighted higher on that occasion.
Yeah. Can I don't want to actually ever indicate that the department or that the court service were playing fast and loose with clients' money, and I'm going to maybe break into where I think reading through the report, and I can't remember exactly where it was, but it did mention, it's Appendix 2. It is cash cases where monies are not necessarily going to be invested because of access. Where is that cash account held, or who holds that cash account?
The cash account is held in my name, but it's held in a deposit account.
It's not in the stockbrokers?
No.
It's not handed over for them to play the market with, because it could be... No,
absolutely not. I mean, it goes back to the point I was making earlier about the protective nature of the Court Funds Office. We're certainly not an organisation that is taking risks with the money that is in our care.
That's the reason I asked the question. I wanted to make sure that there was no indication of that.
We can give you an absolute assurance on that.
But it being held in a deposit account, does it attract any interest whatsoever? Well, considering that some of that monies might be there from someone who's 2-year-old until they're 18, so it could be there for 16 years.
It's currently attracting around 0.5%.
Yeah.
So it basically tracks the Bank of England base rate,
which means it's rock bottom. They'll soon be charging you money to put money in the bank. That's the way it's. Well, I think they actually do that anyway. But as part of the tendering exercise, 6 options were identified. 4 of them were assessed, and in paragraph 3.12 on page 20 of the report, is it fair to say that the OF or the CFO left insufficient time to fully consider all of the options without risking loss of clients' funds?
No, I don't think that. I don't think that is fair to say. I mean, we went through in 2012, 2013 a process that was overseen by CPD and confirmed or met their standards and requirements. So I don't think it's fair to say that we left it to the last minute. I think it was done in a timely way.
I'll just want to make sure, and have you put plans in place to ensure that you have sufficient time to consider all options prior to the next procurement exercise?
I mean, absolutely. I mean, the current stockbroker was appointed on a 3-year term with the option of 2 further 1-year extensions. Yes. So, there's absolutely plenty of time to consider, first of all, whether we want to look at the extensions or whether we want to move to procurement.
You might well need that time, because I do understand, from listening to what happened here today, that the wheels of both Justice and the Justice Department move extremely slowly in some cases, depending on what they're dealing with. But
we will certainly do it in line with the CPD requirements, and we'll obviously work closely with colleagues at CPD to do that.
I appreciate that. I was interested, and it just brings me back to the performance area, where I want to just check, is there an indication, and you did mention about benchmarking against other jurisdictions and how they perform with their court funds. I have some concern that, is that a proper way to be looking at it? Because, private investments tend to do fairly well, where individuals are keeping a very close eye on how their money is being worked and how it is being invested. And I appreciate that there is some calculation, yes, and appreciate we are following a stock market which can be sometimes quite volatile, but you're going to hedge your, and I'm not going to use the word bets on many occasions here, where you will be sure that you're going to come out on the right side fairly well. And over a period of 5 years, you would expect a reasonable return on an investment. And coming from a background that I do, you like to see that you're getting maximum bang for your buck. And to ensure that you do that, I'm not that benchmarking that you did mention only mentioned what happened in other areas, and some of them could be failing really bad, doing really badly. It's a bit like the talents that were given out to individuals. Some actually decided, well, I want to be sure whenever we come back in 10 years' time that the master, I'll have it, so I'll bury it in the ground, and he'll have it. But the man that he gave half a talent to, or gave 1 talent to, and he came back and he had worked it and he had turned it into 4, that man's the one that should be rewarded. I'm wondering just exactly what way you work with clients.
I mean, I think we certainly want to protect the funds that we've been given. This is, as the Chair indicated at the start, this is money belonging to some of the most vulnerable in society. So our primary objective ought to be and has to be protecting that fund. I think it is right to benchmark against the FTSE All-Share Index. Richard can give you some statistics in terms of the rate of return that we've been getting in comparison with the FTSE, which I think are quite impressive.
Yep. I mean, from year end of 2011, the equities under our management increased by 11.6%. The FTSE All-Share was 5.4%. 2012, the FTSE All-Share actually decreased by 2.1%. Our investments increased by 7%. 2013, 17.4% for CFO investments, 12.6% for the FTSE. 2014, 6.2% for our investments, 5.2% for the FTSE, and the year-to-date 2015, 6.7% for CFO investments, 1.9% for FTSE All-Share. So, I mean, we're definitely outperforming the market in that period.
And we're doing it within that protective environment, which is the important issue for us.
Well, that's helpful to hear and to know, and I appreciate that. That's clients' money. But it's how the fees are brought about now. Appreciate they're receiving somewhere in the region of £430, or 430,000 is the fee that's paid to the stockbrokers to manage this account. And appreciate that we have, as alluded to, it's not maybe just 14,000 individual investments. It is 3 major funds that they are managing over that period of time. Those 3 major funds and whatever movements they require. Is that comparable to what people would expect if they were handling a pension fund? Similar of a quarter of, or of almost a third of £1 billion?
The fees that are charged are based on a factor of the valuation of the investments under management. The charge at the most recent tender, the larger clients are charged 0.27% per year of the value of their fund under investment. If you compare that with what you would expect to pay in the private sector for a private client going for a similar service, you would be expecting to pay more than 1%, 1.2% potentially. So certainly in terms of comparison with private sector, I think there's a definite clear benefit with the funds in court.
Thank you very much. Thank you.
Call Mr. Alex Easton. Sorry, Mr. Beggs first.
It's a brief one. Can you give us some idea of the actual amount of cash that you would issue to clients each year? How much money, cheques, would you post out to support them?
I think whilst Richard's looking for that figure, I think it's just to set the context. We wouldn't just be posting cheques or cash out to clients. And if clients want to withdraw money for their fund, then they need to go to the court in terms of getting approval for that. But in terms of the actual figure,
just roughly.
For example, in the month of January, we made payments out of court totalling £4.3 million in the month of January. So
very normal, would it be? So
yes, I think sort of
50
million would be wouldn't be unusual.
Why do you then keep £87 million in cash deposit, as in your analysis of 2013, and get what percentage return on it?
0.5.
0.5. So why keep 87 million if a typical year you turn over 50 million?
Depending on the value of the money and the duration that we would have it for, we would take the decision that a significant amount of money should be held in a cash deposit account. So, for example, if it's less than £3,000, if it's been held for less than 2 years.
The whole thing, there'll be all sorts of variations in there. A typical year, if we went back the previous year, how much was their turnover in that year? You're giving this spin that it's all down all these individual situations, but there's bound to be a sort of a rough line, an average cutting through it, and that's why I wanted to get an idea of why you were keeping almost a third of your money in a cash deposit where you're getting 0.5% interest when you could be getting 6 up to 17% interest over the last number of years by investing it.
Each client is basically allocated, or the cash that is held is allocated to that client. So therefore, if the money comes in and that client is not having funds invested, then that will go as cash.
So who
because
decides
we consider
to keep
it
so
on
much
a client
cash?
by
Is this
client.
the judge deciding that all this money is sitting in the cash account?
The cash will be determined by each individual client. So, for example, if a client has 15,
who takes that decision?
Well, it's the stockbroker's recommendation, and the judge will make the decision.
Ultimately, it's the court's decision where the money.
Can you see why I'm a bit surprised if you have a turnover 50 million that you have £87 million in your cash account?
It's the way it's managed because we're basically
because of the way you're set up in the legislation. Would that be it?
It's the way that the office manages the cash, because we are treating it as that person's cash. We're not investing a pooled fund. We're not treating it as a pooled fund.
Why are you not treating it as a pooled fund? Would you get a better return of the money for the clients if you treated it as a pooled fund? That's a question that I would ask you.
You may, you may, Chair, but as Mr. Ronaldson has indicated, that isn't the way that.
No, I'm not. My question is, would you get a better return for the clients if it was treated as a pooled fund, and would it be less would there be less administrative burden if it was treated as a pooled fund?
I'll give you an example because.
Sorry, Mr. Armor, could you answer that question? Would it be less administrative burden if it was treated as a pooled fund, as most investment companies would actually operate in those sort of conditions?
Yes, possibly. I would accept that. I think.
But possibly, is that a yes or a no?
Well, I would accept it. Yes. I mean, if you were holding it as a pooled fund,
Okay. So what's stopping you holding it as a pooled fund?
Because we hold them as individuals in terms of the money.
No. What is
that's
stopping
held.
you? That's the way you do it. What is stopping you? What's stopping you going to a better system that would benefit the individuals?
I mean, it's held in the
I'm
funds
not
are
asking
held.
how it's done. I'm asking what is stopping you going to a modern system to benefit your clients.
Well, I would certainly look at that. I've not looked at that as an option in terms of whether there are strong benefits there. But we'd have a look at it.
Why have you not looked at it?
Because we hold the money for the individual in my name, and it's dealt with in an individual way. And the protection of the court is there rather than pulling that money.
Could I just add that England and Wales do use pooled funds?
I didn't know that.
But they don't offer the level of service that we provide.
Do they provide a better return on investment?
The amount of funds that are invested in their pooled funds total 5% of all funds that they hold in court. 95% of their funds are held as cash. When you look at ours, we invest 50% or more. So we're obviously happy that we are providing a better service than England and Wales in terms of the pooled service.
But would you accept it might be able to be even better?
That is something that we'll obviously have to consider in the future.
Thank you, Mr. Chairman.
Would not be also riskier as well? Down that road of pooled funds.
Riskier if you put it in pooled funds. I think there is a danger, yes, but we will certainly have a look at that.
I mean, I think it cuts out the flexibility that we have under our current system.
Sorry, Chair.
Paul, just to get my head around this, are you saying there's millions of pounds overnight in banks that attracts an interest rate of 0.5%?
Yes.
No, sorry. The money is held with the Debt Management Office, which is part of Treasury, so it's not in a commercial bank.
So it's the Treasury's benefit from it?
Yes.
Do you think the Treasury should be benefiting from money belonging to the most vulnerable people in society?
Well, the legislation requires us to hold the money in that way. We are tracking the Bank of England base rate. That's the return as it currently is. At a time, it was much better than that, but it is what it is at this current point in time. But we're required to do it in the way we do.
I just asked the question because I am familiar with organisations that attract 2.5–3% overnight. Only it's not been used. Mr. Girwan, if I could interrupt you.
Just one point, and it's very small. Do you take any monies out to manage, to run the court service? There's monies that you're working with. No money comes out of that at all.
Not at this point in time. We're not, because the interest rate is so low. The Court Funds Office is administered by the court service from within the grant we receive from the department.
I note you say not at this moment in time.
Well, if at a point in time when the interest rate was much higher, yes, the legislation certainly allowed us to do that. But we haven't been doing that for a number of years.
Look back to the 1980s, late 80s, where there was maybe 16–17% interest. Were you taking monies to run the Court Fund Office out of that at that stage?
I suspect we were back in the 80s, but no, I couldn't really comment on that far back.
I confirm that the cost recovery exercise was brought in 1997. So between 1997 and 2010, we recovered the costs of running the office. But since 2010, we've been unable to do so.
I'm interested, just you state you've been unable to do so because interest rates have been, well, I wouldn't say you've performed fairly well, with the return that you've been getting, but I'm just interested to find out that potentially, if interest rates increased and your return from your investments increased, you would also be taking some of the most vulnerable people's reward to actually run the Courts Office?
Well, that's a slightly separate issue. I mean, the report does make reference to the need to look at the cost recovery in terms of the Court Funds Office. One of the things that we do want to do moving forward is to have a public consultation in terms of our charging regime, because at the moment it's being met from within the court services allocation. So in effect, the taxpayer is paying for this. I think it is right that that the client should be contributing towards the cost of that, but we would want to have a public consultation exercise looking at what the options would be in terms of full cost recovery in line with the FP requirements.
And just to go back on a point, and it's about cost recovery and legal issues. Does the current legal framework allow you to do that?
Yes. In terms of cost recovery, yes, it does.
The Administration of Justice Act provides for this. It's not something we came up with.
I appreciate that.
Yeah, it covers both court funds in England and Wales and here, and it provides for any surplus income generated on money on deposit with the Treasury and the Debt Management Office to be used to defray the running costs of the Court Funds Office in England and also the Court Funds Office here. And that's what Parliament provided in the Administration of Justice Act.
I'm very conscious that time is moving on, and we have still a number of people who have questions to ask. And maybe just to keep it tidy, we address the questions through the chair. Mr. Alex Easton.
Thanks, Chair. Richard, the Audit Office found a number of cases with concentrated portfolios by which their nature exposes clients to a higher level of risk, which is in paragraph 4.7, page 23, if that helps. Why was this allowed to happen, and what action is the CFO taking to increase diversification and reduce the risk that client funds are exposed to?
The number of cases this refers to is 9 cases. These are legacy cases, I suppose, where the investments were bought many, many years ago, potentially in the 70s, 80s, and have huge capital gains tax implications if we were to sell them and put them into the new portfolios. So there is an assessment of these. Obviously, each year we make use of the capital gains tax allowance, but there is an assessment of these based against the individual client needs and the age of the client as to whether to crystallise that liability would be beneficial to the client or not. So that's the position we're in. Those 9 cases, obviously, at the minute, it's not beneficial to crystallise the full liability.
Okay. Are there any cases where the clients have suffered significant losses as a result of the poor investment decisions?
We're not aware of any cases, certainly in the last 10, 15 years, where there have been significant losses.
Okay. Go on to the next one. Nick, you're next. The Audit Office report indicates that the CFO has been remiss in monitoring stockbrokers' performance. Specifically, the CFO no longer set investment guidelines for the stockbrokers to follow, which is on page 22. In September 2011, when you requested a risk metric from the stockbroker, the information provided was of poor quality, which is on page 23. And compliance with the Global Investment Performance Standards is not monitored, which is page 23 as well. Although the existing contract was awarded in July 2013, it took almost a year before you started to receive attribution analysis from the stockbroker, which is on page 24. Would you acknowledge that the CFO has failed to manage the stockbroker's performance robustly? And how will the CFO ensure that it monitors performances more closely in the future?
Well, I think we've accepted, by accepting the report's recommendations, that we can we can strengthen the governance around this. But I think there are a number of points there, and the experts will correct me if I've got it wrong. In terms of the investment strategies, I think both the previous stockbroker and the current stockbroker investment strategies have been agreed by the JLG. The portfolio approach has been approved by the JLG. The parameters that the stockbrokers work within have been agreed by the JLG, and they are monitored very closely by the CFO. I agree that the new independent financial member on the JLG will strengthen and may be able to provide additional advice about additional oversight we can provide in terms of stockbroker performance. But in terms of benchmarking against performance, as we've just been discussing, in terms of monitoring the implementation of the contract, and the tender for the 2013 contract did set out, I think, the required standards of the stockbroker. And the performance of the stockbroker against the contract, as well as in terms of investment returns, is closely monitored. I think the CFO has been doing a very diligent job. I agree that we can strengthen it further, and we're looking to this new independent person to help us do that.
I think I can give you assurance in terms of the contract management. The contract is very clearly defined with our stockbroker in terms of what our needs and our requirements and our expectations are. We do manage that both through the Court Funds Office and the daily contact with the stockbroker, but we also have formal contract management arrangements in place within the court service. I mean, we did an assessment quite recently, and I've already touched on these points earlier today. But the advice and the administrative actions of the contractor are all taking place within the agreed timescales. The performance, as we said earlier, is consistently higher than the FTSE All Share, and our fees remain very competitive in comparison with others. So we are managing the contract and that relationship, as Mr. Perry said, very diligently.
Just one very last, very quick thing. Ronnie, I'm just curious, why are the accounts in your name?
Because that's what the legislation requires. The Judicature Act requires that all funds are held in the name of the Accountant General. Sadly, it's not my personal name, but they are held in the name of the Accountant General, and that's the role that I currently fulfil. It's a dual role with my Chief Executive responsibilities.
So you're worth a robin then?
The Accountant General certainly is. Unfortunately, I'm not. But
okay. Thank you, Chair.
Thank you. Now move on to Mr. Beggs, who has a couple of questions to ask on the quality of the service provided to the clients. Roy.
Thank you, Mr. Chairman. In the Chair's opening remarks, he had touched on the issue of performance and targets, and yet this information doesn't seem to be easily accessible. And I noticed in the Audit Office report, paragraph 5.9. The performance or the targets were once on your website, but after 2010 it disappeared. I noticed in paragraph 5.3 that information on performance against targets is not provided to clients. In paragraph 5.6, the very bottom, it says, as costs are deducted annually at source, clients do not see a direct charge to their funds. It doesn't strike me as being a very open and transparent operation. Would you care to comment on that, Mr. Armour? I
mean, I do think in recent years a significant amount of work has been undertaken to develop customer service and transparency. Do you accept that there is more that we can do in the new IT system? Will undoubtedly help us to do that. Our performance targets are, as I said earlier, in the annual report, and that is on the website. In terms of the point you made around the management fees, we are now advising clients up front what those fees are. In terms of the stockbroker, we do have, I think, very good user-friendly material that individuals coming within the court service and their representatives can have and can use. We have a very effective, I think, customer service team working within the office. So I think there is a lot more information there now. I mean, I think it is worth saying to the committee that the Court Funds Office have received very, very few complaints. I think it's 3 in the last four years. So, my assessment is that our clients are satisfied with the service that we're providing them. But one of the things that we are now doing, we've launched a customer questionnaire. So we will in time be able to substantiate that.
You said that you felt that the clients were satisfied, but I understand your last customer satisfaction survey was in 2006.
Well, I'm saying that the customers are satisfied on the basis of the lack of complaints that we're getting from.
Do they know how to complain?
Details of complaints procedures would be on our website. We are in very regular contact with a very significant number of our clients. As I said earlier, the official solicitor represents a number of our clients and would be in contact with them. So I don't think there is an issue there. But we are on the back of a recommendation in this report are doing an assessment of quality through a customer service questionnaire.
I'm pleased if you are carrying out a customer satisfaction service, because ultimately that's the only way to be sure rather than feel. Would you agree?
Yes, I accept that.
Thank you. In terms of publishing information, then you've talked about the annual report. Apart from the annual report, will you be publishing in an easily accessible format your key targets and ultimate performance in an easily accessible fashion?
Well, certainly, we do publish them on our website. I think when we get the new IT system in later this year, it will enhance that interaction between ourselves and our clients even further, and that is something that certainly I would want to do moving forward. Yes.
The charges of the Court Funds Office are normally charged against clients' funds, although that hasn't happened this last number of years because of the low interest rates, and there's the large amount of money you've had invested in there. And I'm just curious, which hasn't brought in a very significant return. Surely it would be reasonable, if the clients are paying for it, that you should be operating as efficiently as possible. And yet you don't have specific efficiency targets. Can you explain?
Well, certainly over the past number of years we have had efficiency targets, and I indicated earlier, I think in answer to a question from Mr Rogers, that we had reduced our staffing complement from 24 down to 20 to 21. So Court Funds Office is not immune from the wider efficiency targets that other areas of the court and tribunal service are facing. We do have a target in terms of when the IT system is implemented. I would expect that would deliver a 20% reduction on saving, for example. So there have been targets and there are efficiency targets coming down the track.
So what are your efficiency targets for this year, or is it all just around your new computer system?
Well, we have been working on the basis roughly of around a 5% reduction, but we are hampered to an extent in what we can deliver within Court Funds Office because of the IT system and the manual backup and support that requires. But as I said earlier, when we deliver that system, we're looking for a 20% reduction in our staffing costs.
Earlier today, you used the word processing quite a number of occasions. People were processing. And I'm just trying to get an understanding of what they are doing when they're processing. I mean, how many new customers will you have each day that have to be logged onto the computer system?
Well, for example, what they're doing is, I mean, when the order comes across from the court, they would be BFing that for the funds, for the money to be brought in.
My question is, how many new transactions related to a new customer would come in each day or each month?
We approximately receive around 50 new customers every week.
50 new customers, 50 people to be logged onto the computer each week.
Yes.
Okay.
And
how many transactions would there be each day on your system?
Well, as we looked earlier, sort of 40 to 50,000 payments would not be unusual for the year, and there would be a similar number of receipts.
So now, 1,000 payments per month?
It will fluctuate. For example,
250 payments a week.
It will fluctuate because
but an average
dividends. But yes, that wouldn't be unreasonable.
So there's some new clients to be added onto the system and there's about 50 payments a week, if I've got it right there. So what else are staff doing? The 20 staff, what else are they doing?
Well, there's obviously interaction with the clients in terms of the customer care team. I mean, they're taking phone calls from client representatives, for example. There is the whole interface in terms of the stockbroker and overseeing that relationship. You know, there's the interaction in terms of the judicial liaison committee.
Aside from the computer system, have you looked at how you can improve your system so you've less processing, people tied up in processes to become more efficient? Have you looked at that?
And the focus of that primarily will be within the new IT system. That will help us to reduce a number of the processes that are currently being done.
And do you need any other changes to enable you to become more efficient, to benefit the clients?
Well, I mean, in terms of benefiting the clients, it would benefit the court service at the minute, because that's where the funding is coming from, rather than benefiting the clients.
But normally it comes from the clients.
I mean, we do on our regularly review how we carry out our business, but we are at the minute in that difficult position that we have the IT system. We've talked through the issues with that, and it is difficult for us to make those improvements until that IT system comes. But thankfully, the end is in sight in terms of that.
Is there legislative changes that would be needed to enable you to become more efficient?
I mean, I don't think there are legislative changes that would impact directly in terms of the efficiency. The key for me, I think, is getting the IT system in. That's the big priority, because that's where the efficiencies are going to be significantly driven from.
Can I turn to the Permanent Secretary? Are there legislative changes you think should be made to enable the system to operate more efficiently?
I don't think so within the way the CFO is currently structured, and I'm sure management are carefully scrutinising what people are doing to make sure that resources are being used efficiently. As part of the wider consultation.
Sorry, given this report, what makes you sure that management are carefully looking at it?
Well, because I know by talking to the Chief Executive that they are. But the wider piece is if as part of
surely this report illustrates that management has not been carefully looking at their system.
Well, in terms of what staff do on a day-to-day basis, I know that, like every other part of the department, the court service is carefully scrutinising what everyone's doing, and clearly, being aware of the IT business case, a significant justification for that is the efficiencies it will help us drive out. But in terms of the operation of the CFO, as Mr Lowry was explaining, there is this wider consultation about whether some of these administrative functions could be outsourced, and that will be part of the consultation exercise.
Just turning to the recovering cost aspect, and at present, if there's surplus from the deposits, that would normally cover your running costs. And I understand it's generally the smaller amounts of money that are held in the deposit account rather than going for longer term investment. Would you accept that that's unfair on the smaller clients that you have, on your clients who have a smaller amounts of funds? Surely that's inequitable.
Yes, I mean, I would accept that there is an unfairness in that. We haven't, of course, been, as I've said, recovering funds from the clients.
But you did up until, was it 2012? Up until a certain date, you did.
Yes, and that is one of the reasons why we're now looking at our charging regime with a view to having a public consultation on what is the fair and appropriate way of doing this.
Can I just go back to some of the information you gave us earlier when you'd indicated that there was very healthy returns on the large funds that you had invested? Some years I think it was at 17%. I think the lowest was about 6%. So you weren't taking any of that money and using it to charge against your running costs, but you were looking at the smaller client who was putting money in the deposit account, and it was looking after your running costs.
Well, individuals in that category that you've referred to would obviously be paying a management fee to the stockbroker for managing their funds. But yes, in principle, what you're saying is right. All of our clients would have cash deposit of some degree or other, so they would be contributing. But I do accept that there is an apparent unfairness in the way that was operated, and that's why, as I say, we want to move forward with a very different charging regime.
Okay. And again, if charges were coming out of all your investments, would that not give you a more stable income source?
Well, that is certainly one of the issues that we'll be looking at in the public consultation. That we have a charging regime that covers our costs and is fair and is seen to be fair.
Okay. Turn to a different issue then. I'm looking at paragraph 5.13, where we know it's important that all clients receive regular and timely updates on their investment, but yet it's indicated here, it's page 33, that 75 portfolio cases slipped through the net, where they were on the portfolio list but not on the brokers list. How did this happen?
It was just a simple error on behalf of the broker at the time. We then, once this was uncovered, we obviously took steps to rectify the position and made sure that there were sufficient controls there. We actually brought the sort of controls in-house to make sure it couldn't happen again.
So are you telling me there are checks in the systems that this cannot happen again?
There are, yes.
Okay. Thank you, Mr. Chairman.
Sean Rogers.
And just, Mr. Armour, just in terms of that driving efficiencies and the importance of internal audit, given the value and the number of client accounts, why was there no internal audit carried out for about 2 years, I think between 2010 and 2012?
You're right, the report highlights that there was a period of just over a year, I think, towards 18 months, when there wasn't an internal audit carried out. There were other pressures, as I understand it, at that time, in terms of the work that internal audit had to do. But I can assure the committee that there has been an internal audit inspection every year since then. The head of internal audit within the department sits on my my audit and risk committee. So there are very clear linkages there now, and we are going through the audit process on an annual basis. But there were at that time other pressures which resulted in there not being an audit carried out, regrettably.
And when the internal audit is carried out, our recommendation, do you then take them on board?
Absolutely. The process that we have in place, the head of internal audit, as I say, sits on the audit and risk committee. He will present his report to that committee, which is a subcommittee of the agency management board. An action plan is put in place, and the audit and risk committee will then will then monitor the implementation of that, and indeed the audit is fed into the department as well, because it's done on behalf of the department, and they have oversight in terms of the delivery of the recommendations.
When you said there were other pressures over those 2 years, what were the other pressures?
That was the there was a court case which I'm answering this because I was the chief executive at the time. If you recall, the court case of the McDermott brothers in the village of Dona, who had been abusing children. One of the issues that emerged in the consideration of that case was there was an inaccuracy in the recording of a court order. It didn't actually materially affect the outcome of the McDermott brothers case. Nevertheless, it came to light in that case that a court order had been inaccurately recorded by the staff of the court office, and I was concerned that might not have been an isolated example, so I redirected internal audit resources to do a complete review of all court orders made in cases involving sexual offences to make absolutely sure that there were no other mistakes made, and they just had to pull resources in, and I judged that it was appropriate to redirect some internal audit capacity for a sustained period of time to do that urgent review. And as the internal audit consideration of Court Funds Office obviously resumed after that exercise was carried out, but it brought to light, the exercise itself, although it's not material to today, did bring to light some issues, and we worked with the Chief Justice's Office to make sure that the orders were being recorded correctly. We found that there were one or two mistakes being made by the courts in some cases about the type of sexual prevention orders that were being made, and that internal audit exercise helped us to fix that. But I simply redirected capacity to something I thought was a much more immediate priority because it was a public protection issue.
Okay, thank you. Thanks, Chair.
All right. We have heard a lot of evidence today on the problems and areas of concern within the Courts Funds Office. I'm sure Mr Lafferty would be pleased with this remark, but it strikes me that it's an archaic Cinderella service in urgent need of reform. You agree with me?
I think we've consensus here this afternoon that the modernisation programme that Mr Armour has described is a priority for us. I just didn't want to give the committee the impression that perhaps we had done nothing prior to the Audit Office report. Its purpose is to look after the financial affairs of the most vulnerable in society, such as minors who have been awarded damages in our civil courts, and those that have become mentally incapacitated and rely on the Courts Fund Office to manage their financial affairs. From what I and indeed my colleagues have heard today, I think these people have been let down and have not got value for money from a service that has been entrusted to look after their affairs. Do you agree?
May I respond to the Chair? I mean, I think this report has shown that there is valuable things we can do in terms of strengthening governance and demonstrating value for money and improving transparency. But the acid test for us, I think, is whether the Court Funds Office provides a good and appropriate level of service, both for the clients and for the court. And I think while we can do better, I think essentially it carries out its responsibilities, as I said earlier, diligently and with great care, and with the concern of the clients at the heart of it. So I take assurance from that.
Okay. That's useful, and just as in my opening remarks, I was simply regurgitating what was in the executive summary of the report, which I think we all signed up to. Members, we have all now had an opportunity to ask questions of witnesses. Are there any final issues that you wish to address before we conclude this session? Mr Laborie and CNEG, is there anything that you wish to add regarding the evidence you've just received?
Chair, nothing to add at this point. Thank you.
Members, do you have any questions you would like clarification on from Mr Laborie or the Controller and Auditor General? Can I thank you all for your attendance before the committee today? It's been extremely useful, and the information received will be taken on board as we develop our report. It just comes to mind, Mr Lafferty, at an early stage you mentioned that you had drawn up a document which would be useful if we had a copy of it.
Is that the investment protocol?
That was the report that they commissioned. Amtech?
Amtech, yeah.
Oh, yes, sorry, there's an Amtech report. Yes, of course,
Right.
we'll make that available
Okay.
to the committee, of course, yes.
Now, you'll be pleased to know that we may wish to seek clarification on issues raised today and on other issues as they arise during our deliberations. Of course, we'll write to you about that. Members, for the remaining items of business, it's necessary that we move into closed session. Are members content that our visitors leave and that we go into closed session? Thank you very much for your time.